Hi, I'm Ed Bacon, the rector of All Saints Church, Pasadena. Whoever you are and wherever you find yourself on the journey of faith, I hope that you'll find something here that speaks to you. Welcome.
Good morning, everyone. I'm so happy you're here, and I'm so thrilled that David Cadell is with us. We have at the table over there red welcome bags for those of you who might be visiting with us today. And we also have an information sheet about marriage at All Saints Church. We're back in the marrying business as a result of this past week's it's really very wonderful. I'm actually quite thrilled that David said yes to a very last-minute invitation to me, because the last time he was here, I found myself saying over and over again in my soul as he was speaking, I want him on the Supreme Court as soon as possible. And you will, after this introduction, get to be taught by him, and you will find out why I felt that way. He serves as the visiting Arnold Cassoy Senior Scholar of Law and Legal Director at the Williams Institute, UCLA. He's an attorney in Los Angeles whose private practice focuses on constitutional and appellate litigation, commercial litigation, and entertainment litigation. David's litigation includes work in both trial and appellate courts, and his cases have resulted in numerous important published opinions, including historic decisions regarding discrimination based on sexual orientation. His litigation has advanced groundbreaking legal theories in connection with constitutional scrutiny of discrimination based on sexual orientation, legal recognition of relationships of same-sex couples, and legal rights of LGBT youth. David also has extensive experience in drafting legislation addressing discrimination based on sexual orientation and gender identity. He received his bachelor's degree summa cum laude from Harvard and his JD degree magna cum laude from Harvard Law, where he was a Supreme Court editor of the Harvard Law Review. Following law school, Cadell served as a law clerk for Judge David S. Tattle of the U.S. Court of Appeals for the D.C. Circuit, and as a law clerk for Justice Ruth Bader Ginsburg of the Supreme Court. Early in his legal career, Cadell practiced constitutional law in association with Lawrence H. Tribe in Cambridge, and he later was a partner at Arell and Manella in Los Angeles. He opened his own law office in 2003 and continues to maintain his private practice in addition to his work with the Williams Institute. He's a frequent speaker about legal issues at universities and continuing legal education events. And he has been honored by numerous legal and civil rights organizations, including the National Center for Lesbian Rights, Lambda Legal Defense and Education Fund, the ACLU of Southern California, and the People for the American Way. And I have named him Visiting Constitutional Law Scholar of All Saints Church. Would you please welcome David Cadell?
Thank you all. Thank you, Ed, for that warm introduction, and thank you, Susan, and All Saints, and Linda Barreau for inviting me to be here today. It is an honor and a joy to be here with you on a day when we have much to celebrate, some things to ponder about, and some things to be disappointed about this past week from the Supreme Court's rulings. I want to thank your church for all that you have done on the issue of marriage equality. You have truly enlightened and educated your own congregation, your community, your denomination, your worldwide communion, and people all over the world. And you've served as an example of how to respect people as equal in dignity, and how a religion and a church can change with the times and accept all people that are here in your congregation and around the community. So thank you very much. You've done great work. You filed amicus briefs. You'd rallied the troops in support of this cause, and it's really inspiring. And I hope you understand the important role that this congregation has played in this important struggle. So this week, the Supreme Court came down with some monumental decisions about equal protection under the law under our federal Constitution, deciding a case on Monday about affirmative action, deciding a case on Tuesday about the Voting Rights Act, and on Wednesday deciding two long-awaited or long-pending cases about the rights of same-sex couples to marry and to have their marriages recognized. I'm going to focus primarily on the marriage rulings and touch briefly on the other two rulings. I think it's important that we all take this moment to truly celebrate the fact that the United States Supreme Court has struck down, after 17 years, the Federal Defense of Marriage Act, which expressly said that for all purposes under federal law, the federal government was going to completely ignore the existence of valid marriages of same-sex couples here in this country. I think it's important sometimes to reflect on our own personal experiences of these types of decisions. I'm a constitutional lawyer, so I live for these moments. Decisions by the Supreme Court on the rights of gay, lesbian, bisexual, and transgender people are actually few and far between. But one of the most important rulings by this court came in 1996, and I want to just put it a little in context to explain how happy I am this week to see the demise of Section 3 of DOMA. In 1996, at the end of that Supreme Court term, the court announced an important decision in a case called Romer versus Evans. Colorado had enacted a state constitutional initiative that amended their constitution called Amendment 2 that said that for all purposes under the law, no branch of government in Colorado could recognize any form of claim of discrimination by any person based on their homosexual or bisexual status. And the Supreme Court issued a profound ruling in that case in 1996, saying that the Colorado law had impermissibly treated one group of people as strangers to the law and said to them, the law will not recognize any claim of discrimination against you. And Justice Kennedy wrote the opinion for the court in that case, saying that our constitutional tradition doesn't know laws of that sort, that basically declare that one group of people will basically not be recognized by the law. Thought it was telling that Justice Kennedy said our constitutional tradition doesn't know laws of that sort because of what happened soon after. It was right after that opinion was decided that, as it happens, I began serving as a law clerk to Justice Ginsburg at the Supreme Court, and so it was a heady moment. I was very excited. The Supreme Court had just decided this important gay rights case, and yet just a couple months into my clerkship, and more important, just a couple months after the Supreme Court had struck down Colorado too, in September 1996, Congress, by overwhelming majorities, enacted the Federal Defense of Marriage Act, which said the federal government will refuse to recognize for any purpose the marriages of same-sex couples. I remember thinking to myself, how can it be that nobody sees that that law has the same constitutional flaw as the Colorado law that was just struck down, because it says that the law will treat you as strangers. And I wondered then how it could be that so many people rallied in defense of that law right after the Supreme Court had said the Constitution did not permit caste legislation. Well, it's very gratifying this week to see the Supreme Court say that the Federal Defense of Marriage Act does indeed share that same constitutional flaw. It was designed, according to the court majority opinion by Justice Kennedy, for the purpose of singling out one group of people, same-sex couples married under state law, and treating them differently, refusing to recognize them under the law for no valid purpose, but rather with the effect of demeaning their existence. So it's wonderful that this ruling has finally come down, affirming that this law passed just a few months after the Supreme Court's decision in Romer v. Evans does indeed share that same flaw. You know, I typically don't like to read during a presentation, but we're at a church, and I think you guys are used to readings. So I'm going to just read a few sentences from Justice Kennedy's opinion for the court striking down DOMA, just to so that you can get a sense, if you hadn't had a chance to read it, of what he found to be some of the major flaws in that law. And what he, as you listen, he identifies the discriminatory effects and purposes of DOMA. He says, DOMA's principal effect is to identify a subset of state-sanctioned marriages and make them unequal. The principal purpose is to impose inequality, not for other reasons like governmental efficiency. Responsibilities as well as rights enhance the dignity and integrity of the person, and DOMA contrives to deprive some couples married under the laws of their state, but not other couples, of both rights and responsibilities. Then later he says, DOMA undermines both the public and private significance of state-sanctioned same-sex marriages, for it tells those couples and all their world that their otherwise valid marriages are unworthy of federal recognition. This places same-sex couples in an unstable position of being in a second-tier marriage. This part I like. The differentiation demeans the couple whose moral and sexual choices the Constitution protects, and whose relationship the state has sought to dignify. And it humiliates tens of thousands of children now being raised by same-sex couples. The law in question makes it even more difficult for the children to understand the integrity and closeness of their own family and its concord with other families in their community and in their daily lives. Yeah. All right, I'll live with the fact that you're clapping somebody else's words. But now you're clapping his. Okay, so I hope you get the sense of the Kennedy opinion. It's exciting. He recognizes that DOMA is flawed because it treats one group of families differently. Now, in his opinion, he's very careful to walk a very fine line in saying, I'm only talking about this section of DOMA. I'm not talking about the other section of DOMA, which says the states don't have to recognize each other's marriages of same-sex couples. And he's not talking about state laws about marriage. He says, I'm just talking about this one thing. But Justice Scalia, who vehemently dissented from this ruling, wrote in his dissent, yeah, the court may be saying that, but if you look at what they've said, it so obviously means that the court will rule that state laws discriminating, or rather prohibiting people from marrying based on sexual orientation are invalid. And Scalia has a nice little trick in his opinion. He takes portions of Justice Kennedy's majority opinion, explaining why Section 3 of DOMA is unconstitutional, and he strikes out the word DOMA and replaces it with references to state bans on marriage and says, see, it's going to be the same thing. We can only hope so. And so, a lot of questions are out there about what this ruling means. In constitutional terms, a lot of people are wondering, does this mean that the other portion of the federal DOMA, which, as I mentioned, says that the various states don't have to recognize marriages of couples, same-sex couples, that are valid under laws of other states, whether that will be valid? The court doesn't say. But again, as Justice Scalia noted, the reasoning of the court, I think, will inexorably lead to the conclusion that a state deciding that it's going to treat all marriages within its state from outside the state as valid unless it's a same-sex couple's marriage is going to have the same flaw as the federal portion of DOMA. Now, that's a matter of logic. Whether the court will actually rule that, none of us can tell. And then another question out there is, well, how does this affect state law bans on marriage by same-sex couples? Again, we don't know. I think that's a harder question. I'll talk in a moment about the Proposition 8 case, and we can return to this issue. And then there are all sorts of practical questions that remain. I'm going to highlight them without discussing them. The court's opinion does not address what happens now to couples who are validly married and live in states that don't recognize their marriages. Is the federal government going to hinge recognition of marriages based on the state in which a couple resides or based on the state in which the marriage was performed? So, for example, if a couple is legally married in Massachusetts, as Justice Scalia gives this example, and then moves to Alabama, what's going to happen? Well, under existing law, there are over 1,000 federal statutes and regulations that confer rights and benefits to married couples. Some of those federal programs base their determination of whether you're married under federal law on the state where you live. Some federal programs base it on the state in which the marriage was entered. And so there's going to be a lot of work sorting this out. And the good news is that Attorney General Eric Holder announced this week that the Justice Department is moving full steam ahead to implement this ruling as quickly as possible. And he's got a whole team of lawyers looking into just this question, and they're going to be providing guidance on this on a rolling basis. As they get the answer for each federal program, they're going to start announcing it. So that's nice to see the government wanting to implement this constitutional ruling, which after all says the Federal Defense of Marriage Act was enacted for the purpose of discriminating based on animus against same-sex couples who are married. And then another set of questions is going to arise because questions concerning timing. Is the same-sex couple's marriage going to be recognized by the federal government as of the time of this Supreme Court decision or as of the date they were married, which may have been several years ago? Will couples' taxes be subject to change if in this calendar year? Should people be withholding based on their married status or not? Lots of practical questions, no answers. We'll have to wait and see what the Justice Department determines on those. So that is the DOMA ruling in brief. And now I want to turn to the Proposition 8 case. As you may recall, Proposition 8 was enacted here in California in 2008 after the Supreme Court of California had said that same-sex couples could marry, and more than 18,000 couples in California did get married, including some at this church. After Proposition 8 was enacted, a federal challenge was filed in federal court in San Francisco, and the trial court struck it down as unconstitutional, violating equal protection and due process protections in the federal Constitution. The governor at the time, Schwarzenegger, and the attorney general then, Jerry Brown, decided not to appeal. So they were content to live with the trial court ruling that same-sex couples had to be permitted to marry. The individuals who had proposed that Proposition 8 be on the ballot, they, along with an organization representing them, filed an appeal themselves in federal court saying, Proposition 8 is valid, please reverse the district court. Without going into a lot of details, the Supreme Court ruled this week that after the trial court ruled that Proposition 8 violates the federal Constitution, since the state of California decided not to appeal, the entire appeal did not actually present a controversy that the Supreme Court could rule on. The court said that the proponents of Proposition 8, those individuals who had circulated ballot petitions to get it on the ballot, did not have a personal stake in whether or not same-sex couples could marry. And so because they didn't have a personal stake in the lawsuit, the appeal could not stand, which means that the trial court ruling will stand. And that trial court ruling is a ruling that Proposition 8 is unconstitutional. And the trial court issued an injunction, an order, against the state officials that are in charge of administering the marriage laws, saying that they can no longer enforce Proposition 8. And the district court's order, we'll get questions later, an injunction applies to all persons operating under their supervisions. And under California law, that includes county clerks who issue marriage licenses. Now, the marriages have resumed as of Friday afternoon, and they're continuing this weekend. It is Pride weekend in San Francisco, and the City and County of San Francisco has kept open City Hall, and people are there marrying. My understanding is that there were approximately 100 marriages there yesterday. How jealous are you that this happens for their Pride weekend and not ours? But, you know, yesterday, those individuals who tried to file an appeal in this case and keep the controversy alive and get Proposition 8 upheld, they filed a petition in the Supreme Court, the U.S. Supreme Court, asking that court to basically put the marriages on hold for until next month, when the Supreme Court's decision that it announced earlier this week will become officially final. There's a 25-day period after a Supreme Court decision is announced it's called a rehearing period, and it takes 25 days for the Supreme Court's opinion to actually become final. Nevertheless, I won't get into the weeds of it, but couples are marrying, and the proponents of Prop 8 are trying to stop them. So we'll just have to keep tuned into what the Supreme Court does. I could go on forever about these cases. I want to touch briefly on the Voting Rights Act cases, the Voting Rights Act case. So very briefly, under the Voting Rights Act, there are certain jurisdictions, states, and localities in the United States that had, prior to the original enactment of the Voting Rights Act in the 1960s, had imposed certain requirements on voting, such as literacy tests, that were plainly efforts to discriminate based on race and to prevent people from voting. And the Voting Rights Act included a provision, and still does include a provision, that says these jurisdictions who have been deliberately trying to keep people from voting based on race, from now on, if they want to change something about their voting rules, like what days the elections are on, whether a city council will be elected at large or by individual district, all sorts of things. Those kinds of changes must be approved by the Justice Department before they can go into effect. That has been the law since the 1960s. In 2006, Congress reaffirmed that law, including a formula to determine which states and which counties should be subject to this requirement. It's called a pre-clearance requirement, where these particular areas that have a history of discriminating can't change their voting rules without getting pre-clearance from the Justice Department. The Supreme Court did not this week strike down that pre-clearance requirement. They said it's okay for the voting rights, well, they actually said we're not going to decide whether it's okay for this pre-clearance requirement to exist. But even if it is, the formula that Congress has been using to determine which states and which localities will be subject to the Voting Rights Act, that formula, the Supreme Court said, by a 5-4 vote, is unconstitutional because, according to the Supreme Court, Congress in 2006, when it reenacted that formula, was relying on the same data it had in the 1960s, and that it was no longer valid for Congress to rely on that data. So the Supreme Court struck down that formula. Now, I'm not a political scientist, but I hear that it's be very difficult to get the current Congress to enact a different formula. So many people fear that the practical effect of this ruling will be that there will be no pre-clearance going on because there's not a formula in place now, and according to prognosticators, it's unlikely that this Congress would enact another one. But you never know. The current formulas had been reenacted in 2006 and signed into law by George W. Bush. Justice Ginsburg wrote a dissent for 3 of her colleagues as well, Justices Breyer, Sotomayor, and Kagan. And in her dissent, she noted that the court majority, the majority opinion was by Justice Kennedy, the court majority was basically using the success of the Voting Rights Act over the last 4 decades as a reason to invalidate the formula. In other words, the court was saying, this formula may have worked a long time ago, but now look how many African Americans are voting. Now, so they looked at the increased voting rates of African Americans and other minorities in some of these districts and said, the Supreme Court said, the majority, see, this shows that this formula is not appropriate anymore. And Justice Ginsburg dissented and said, wait a second, the reason these formulas may look unnecessary to you is because they have worked, and they have been working. And I think a message to get from that opinion is that regardless of success in these civil rights movements, there is constant need for vigilance, including vigilance that the successes we obtain will be used against us as supposed evidence that legal protections are no longer necessary. And there is a huge difference between people not discriminating because the law forbids it and people in governments voluntarily choosing not to discriminate. And I think we always have to be careful not to assume that because legal prohibitions on discrimination are working, that in their absence, discrimination would also disappear. And I'm going to link this to the marriage cases briefly, and then we'll open up for questions. The linkage I want to draw is this, that one issue the Supreme Court did not decide in the DOMA case is whether laws that discriminate based on sexual orientation should be subject to a higher level of scrutiny by the courts under the Constitution. In the DOMA case, the Supreme Court didn't need to reach that question because it found that DOMA had a purpose and effect of trying to discriminate against gay people, deny them equal dignity under the law. So the Supreme Court did not need in the DOMA case to go further and say, hey, in general, do laws that discriminate warrant higher scrutiny, because it was so obvious to the court majority that DOMA couldn't survive any level of scrutiny. But that question remains out there, and one of the principal arguments that advocates for LGBT equality have made is that legal protections are needed for gay and lesbian people because of a long-standing history of discrimination. And when we make that argument, the other side chimes in and says, oh, but look at all these states that are letting you marry now. Look at the protections. Look, don't ask, don't tell is gone. What are you complaining about? And in other words, they're trying in the gay rights struggle as well to use the successes that are coming after decades and decades of work to be used as a reason not to extend further protection under the Constitution. So just something that I think for all these civil rights struggles, we have to keep our eyes open. I'm going to open up to questions now. Thank you all very much.
On my way over, is this working? On my way over, I heard on the radio.
Wait a minute. Is it on? Try again.
On my way over, I heard on the radio that Justice Kennedy refused to hear the appeal.
Excellent. Thank you.
We have up-to-the-date reporting here.
Excellent.
On Wednesday, Melissa Hayes Perry on MSNBC said that both cases, the DOMA and the Voting Rights Act, were just indications of the Supreme Court ripping more power away from the federal government and giving it back to the states. And I wonder if you'd like to comment on that.
Okay, well, I think it's interesting in the DOMA case. One thing that I think advocates for marriage equality were concerned about was that in deciding the federal DOMA case, the Supreme Court might say marriage is exclusively the province of the states, and the federal government doesn't have much to say about it. And the reason that LGBT advocates were concerned about that is they didn't want that point to be used against the later case that the states must let same-sex couples marry. Now, fortunately, the majority opinion by Justice Kennedy goes on at length about the fact that marriage has typically been the area that states have control over, and that the federal government doesn't normally play a role in deciding who is married. But significantly, Justice Kennedy says expressly that the court is not deciding the case on federalism grounds, in other words, grounds that are related to the relationship between the state and federal government. Instead, he uses that federalism point about states usually being the ones who determine who's married as evidence of DOMA's discriminatory effect and unusual nature. He says, I'm not deciding it based on states' rights. I'm deciding it based on equal protection and due process. But if you look at the unusual nature of this, it's an indicator that this was indeed designed to hurt same-sex couples who are married.
Okay. Yes, Ray?
Regarding the Prop 8 case and the determination that the defenders of Prop 8 did not have standing, at first blush it seems very curt and superficial, but I think that it's deeper than that. It means that none of those folks are harmed by the law. And if no one is harmed by the law, then there's no reason for the law, or something to that effect. Could you expand on that and how the fact that they don't have standing could possibly be used to further marriage equality in other states?
Well, that's interesting. One way the ruling will help in a practical way in other states is that organizations and people who do not want same-sex couples to marry regularly try to inject themselves into lawsuits in which the validity of marriage restrictions are being determined. And they claim they have some special interest. And courts have very often said, no, you really don't have a special interest here. You don't have anything. You're not harmed by the issue of whether same-sex couples can marry. So I think this decision is helpful in that regard. I also just want to say there's a lot of talk out there about, oh gosh, this will really endanger the initiative process, because if the Attorney General of California decides not to defend an initiative, no one's going to have any standing to do so. That won't usually be the case. Proposition 8 was an unusual law. It did not have any purpose of benefiting anyone. All it did was hurt same-sex couples. Normally, a law, if you think about it, actually helps someone. And if the Attorney General of California ever declined to defend another law, I think you could expect there'd be someone out there who could say, actually, I'm going to be harmed if you don't enforce that law. And therefore, they would have standing. So I don't see this ruling as any threat to the initiative process. I see it as highlighting the fact that Proposition 8 was up to no good. Literally, it didn't do any good for any person.
I'm wondering if there's any decision or any details yet on military families or gay military people who marry, about benefits and things like that as employees of the federal government.
I don't have any details, except that I will say the Attorney General announced this week that he wants it to be a priority in every department, and the Department of Defense is moving quickly on this. I think it's going to be a lot of really great news, but I can't predict the future. But I think that's one area where things may move quickly.
Right here, please.
So if the ruling from Justice Kennedy was based on due process and equal protection, how far stretches it to apply the 14th Amendment and to use that same reasoning against all the states?
Well, as a general matter, this is technical legal talk, the Supreme Court tends to interpret what equal protection requires similarly against the states as it does against the federal government. It's not exactly the same, but so I think the principles will apply if a state does something that is determined to be like DOMA, in that it's designed to create two classes of families, one that will be recognized by a government and one that won't. Again, Justice Kennedy is careful to say, I'm not talking about anything else, but I think you can do what Justice Scalia did and just take his opinion, cross out the word DOMA, and put in state marriage bans and ponder. And I think the reasoning will apply. The holding, the official ruling of the court, doesn't determine the question, but the law ideally is supposed to be based on reasoning and rational development of the law. And I think this will, if taken to the conclusions that it logically leads to, will be very helpful.
Wasn't the Prop 8 case a Ninth Circuit case?
Yes, it was.
You referred to it as Supreme Court.
Oh, well, it's just in the Supreme Court this week, but they said there's no standing. Maybe I misspoke another way, but that case was in the Supreme Court.
In the Prop 8 case was lack of standing of the appellants, right?
That's correct.
Okay. Would you mind telling us the names of that case and the DOMA case?
Yes. So the Proposition 8 case is called Hollingsworth versus Perry, and the name of the federal DOMA case is United States versus Windsor. That was easy. Thank you.
Hi, good morning. I have a question for you I hope you can speak to. Something I've been hearing that just doesn't appeal to logic to me. I'm hearing in some churches, especially in LA, that because of what's going on, that churches can be sued, or there are legal actions that people can take against churches that don't perform same-sex marriages, and that it may affect their 501c3 status.
Okay.
Does that sound?
So first of all, if you hear arguments that these rulings may in any way affect the marriages that a religious body must celebrate, the answer is absolutely not. We have a First Amendment to the United States Constitution that protects religious liberty and prohibits the establishment of religion. And the First Amendment, as well as California's constitutional protections against religious discrimination and prohibition of an establishment of religion, will clearly make it the case that no church, temple, or mosque, anybody has to perform a wedding they don't want to. Just to put it in context, no one has ever forced you guys to perform a wedding you didn't want to, have they? No. So it really won't have any effect. Oh, sorry.
There were, of course, three major decisions this week. And looking at them, I'm a little worried. It looks like the concept of equal protection is actually being reduced to equal justice. In other words, if you're okay if you are trying to advance the causes or cure discrimination in the past, now there's not as much protection for it. I think you talked earlier about how these were very special cases, and it seems like, for example, in the affirmative action case, the court was telling the University of Texas, no, you can try to, you can seek diversity, but don't put so much emphasis on race. And in the Voting Rights Act, it seems to be unwinding things. And I didn't hear a whole lot that you said about the marriage cases that makes me believe that they would go further and allow some type of protection rather than just equal justice. I don't know if... It's been a long time since I had a constitutional law course.
Oh, that's fine. That's fine. You know, I think what is animating the affirmative action and the Voting Rights Act cases is the vision of one person, Justice Anthony Kennedy, that our Constitution should be colorblind or race blind. He wants government not to be taking into consideration race unless they can satisfy a very strict test. And so I think that is what is behind both the affirmative action and the voting cases. And in the marriage cases, I think Justice Kennedy, in contrast, is open to the possibility that our understandings of what equal protection requires are changing through time and we're maturing. And he has a quote to that effect, that basically people are coming to understand have a fuller understanding of what equal protection requires. And he has said that before in some of his opinions on LGBT rights issues. So when it comes to sexual orientation discrimination, Justice Kennedy sort of is having, over the course of the last 17 years or so, is having an awakening, and thinks that America is having an awakening to what equal protection requires. And I think in the race context, maybe he thinks it's an awakening, but it's a particular vision he has that the government shouldn't take race into account.
Before you move on from that, you know something about the mind of Justice Ginsburg, who's so fascinating to us, and you've worked for her. Can you talk a little bit about the difference between Justice Kennedy's mind and Justice Ginsburg's mind?
I can't say for sure. One might be sharper than the other, but I don't know. Just kidding. To either one of you, if you're listening. Well, I think there's something they share, supposedly. Well, I'll just say, here's something Justice Ginsburg believes. That you shouldn't go farther in a case as a court than the case actually requires you to do. And so, though she may have a broad vision of what equality requires, she hews very strictly to the principle that the court, when it has a case, should decide just that case and on very narrow grounds. I think that view is correct, but it can be frustrating, particularly if you know where her, if you look at her history and what she regards as equal protection requiring. Nevertheless, she is true to her understanding of what a judge's role is, which is to decide the actual case in front of them. I do think that though this week is cause for concern in the Voting Rights Act cases and cause for some celebration in the marriage cases, I do think in each of the cases the court majority attempted to follow that principle. So in the affirmative action case, they didn't say that University of Texas policy was unconstitutional. Justice Kennedy just said the court applied the wrong test, and he spelled out clearly what the test was and said, lower court, you must consider this again. In the Voting Rights Act cases, the court did not strike down Section 5 that sets forth the preclearance requirement. It chose to strike down the formula. Now, we may have our views about what the practical effect of that is. In the marriage cases, in the Proposition 8 case, the court decided, we don't really have jurisdiction to decide this. In the DOMA case, the court said, we're only deciding the very precise question in front of us: how must the federal government treat same-sex couples who are validly married by a state? And the court did not go further to talk about the rights of LGBT persons. And in fact, I can't end without sharing with you a very remarkable thing about Justice Kennedy's opinion in the DOMA case. He focuses exclusively on same-sex couples validly married by a state and never uses the words gay and lesbian. The only references to the word homosexual are quotes from the House report on DOMA. And so if you look just at the words of the opinion, it's not talking broadly about the rights of LGBT people or those of us who are LGBT and not in a same-sex couple. It is focusing on these same-sex couples who are validly married. That said, I think it's pretty clear who's in those couples, and I think the opinion will have broader effects.
Last question.
Just real quickly, I'm intrigued by the dilemma of same-sex couples who are married in Massachusetts and move to Arkansas. Are they going to have to sue each one on each issue? Or what? How can this be settled?
That was Justice Scalia's question, but he used Alabama instead of Arkansas. I think the results will be the same. You've asked some important questions there, and they truly are open questions. As I mentioned before, currently the federal government uses different rules for different federal programs. Some federal programs are based on whether the state you live in recognizes your marriage, and some are based on whether the state you got married in recognized your marriage. So it truly is an open question, and the Obama administration has announced they're going to be addressing that very question as quickly as they can with respect to all the statutes and regulations that are at issue.
Thank you, David Cadell. And when you get on the bench, man, you can remember I played.